According to me, the Allahabad High Court's reading of POCSO law is wrong.
The Allahabad High Court has reduced the sentence of a convict who forced a minor to have oral sex with him from 10 years to 7 years of imprisonment. The judgment has been received critically over social media, as many say that the court has observed that oral sex with a minor is a less serious offence. But is that true? Let's understand the judgment as the lawyer, researcher and human rights activist Vrinda Grover explains why she thinks the judgment is legally wrong.
This is a case where a 10-year-old boy, there was accused put his penis into the mouth of a 10-year-old boy and he also ejaculated. The trial court convicted him for aggravated penetrative sexual assault. The High Court says this is not a case of aggravated penetrative sexual assault, it's only a case of penetrative sexual assault. So the man continues to be convicted. He has not been acquitted. According to me, the Allahabad High Court's reading of POCSO law is wrong. Section 3 of the POCSO Act defines the offense of penetrative sexual assault, which includes putting the penis in the mouth, the anus, or any other body part. So it is an offense of penetrative sexual assault, which is punished under Section 4 of POCSO. Section 5 of POCSO talks about aggravated penetrative sexual assault. It does not define any act. It defines the circumstances under which penetrative sexual assault. So the act will remain the same, which will be putting penis in mouth. The penis could have been put in the anus. It would still be penetrative sexual assault. Section 5 describes in what circumstances it will become aggravated penetrative sexual assault. So these are coercive circumstances where the power of the perpetrator is even greater over the victim. Section 5M says that if the victim is under 12 years of age, if the child with whom this penetrative sexual assault is committed is under 12 years of age, then this will be a case of aggravated penetrative sexual assault, which is punishable under Section 6. The thing that changes between Section 4 and Section 6 is the mandatory minimum sentence is higher under Section 6 and a little lower under Section 4. This is a case of aggravated penetrative sexual assault because the age of the boy is 10 years of age. To my mind, the Allahabad High Court has misread the POCSO law. The law under Section 5 does not say a new act has to be committed. It says in what circumstances. And one of the circumstances is under 12 years of age. And that is where I think the Allahabad High Court, in my opinion, its verdict is erroneous. The judge has not made an observation. The judge has passed an order. I think the order is not being read. He has convicted him. He has not said this is not a crime. So it is really up to the media to ensure that the correct information about the judgment is relayed to the public. Unfortunately, in the world of social media and Twitter, it is now being understood as though the judge has said nothing has happened. That's not correct. The judge has convicted him for a substantial period of years. The law says it is even more coercive and therefore it should be taken up differently. However, it is now up to the media to communicate both the law and the judgment correctly. I don't think any wrong message is going out to the public. If the wrong message is going out, it's because we are not reading the judgment. I don't think the two can be equated. They can only be equated to the extent that the court is not reading the POCSO Act clearly and not understanding that POCSO Act was made to protect children from sexual abuse, and therefore they should give effect to the words of the statute, as has been said by the Supreme Court in the case that was filed now in the name of the Attorney General against the skin-to-skin contact. The Attorney General had filed, and the Supreme Court has given a very clear verdict saying, please understand the objective of POCSO. It is to protect children from sexual abuse and to understand the impact it has on their psyche, on their emotional growth, etc. It is also saying courts must read the POCSO Act and give meaning and effect to the words of POCSO Act. Here again, we see that the Allahabad High Court has failed to read Section 5 of the POCSO Act, which describes the greater coercive circumstances in which, the law says that if the child is not just a minor but very young, therefore under 12 years of age, the impact on the child and the vulnerability of the child is even greater.
Subscribe to Midday India. Get direct notifications on all our videos by clicking on the bell icon.